Good morning. This second session is being devoted to amendments to the Code of Civil Procedure under the Commercial Courts Act of 2015. And for this particular session, we have with us this morning Justice Rajive Bhalla. He is a blend of a lawyer and a judge. Joined the bar in the year 1978 and continued till the year 2003. Thereafter, he was elevated in the year 2004 and retired in the year 2016. 25 years as a lawyer and 12 years as a judge. What a blend, what a mix of experience, both of the bar and the bench. And after retirement, after heading the tribunal, Punjab Education Tribunal, he is once again in the domain of a lawyer. He is contributing immensely in this particular process, and particularly the Civil Procedure Code in relation to the Commercial Courts Act. The kind of changes which have been made is actually the domain of Justice Rajive Bhalla. And therefore, we thought it appropriate to have Justice Rajive Bhalla for this particular session. To mind, no one else could do justice to a topic of this magnitude. I'm conscious of the fact that the topic is so vast, and to capsule it in 1 hour is not an easy exercise. But knowing the skills of Justice Bhalla, I'm sure he would really make this particular session a hugely contributory session. Over to Justice Bhalla, please.
Good morning, sir. And before I start, as usual, I'll pay respect to my teacher, Dr. Balram Gupta. He taught me in the law college. Then he became a lawyer, a senior advocate, and now he's the director of the academy. So I have many memories and many connections with him. Now, thank you, sir, for having me here, and good morning to everybody. Once again, thank you for the kind words, totally undeserved praise. But I'll straight away dive into this topic, which I, like rightly said, in 1 hour, I don't know whether I'll be able to even do it. So I plan to just rush through it to give you a bird's eye view, because some of you may be doing commercial courts and some of you may not. But I think eventually everybody will get a chance to head a commercial court or do some work. So the Commercial Courts Act 2015, and which has been amended twice, thrice again, brought certain significant amendments into this monolithic code called the Civil Procedure Code, which I think you'll all agree with me is totally out of step with today's demand for speedy justice. Schooled as we all are and shackled as we are by the rules of procedure, more often than not, justice gets sacrificed at the altar of procedure. This act is maybe one attempt to unshackle justice, but unfortunately only for commercial disputes. I've been asking this question, why only for commercial disputes? Why can't this procedure be extended to all civil disputes? But as usual, Parliament will take its own sweet time, maybe another 20 years before it decides to amend the CPC. So now I take you straight away to the provisions of this Act. You may be familiar with it, and I'm quite sure all of you will be. But Section 2E defines commercial disputes in an inclusive definition from Roman 1 to Roman 22. It includes all sorts of disputes. In fact, I find very little disputes that are left out. Even your agreement to sell, your lease deeds, which are not covered by the Rent Act, everything is covered here. And there's two very important explanations. I will not go through this because of lack of time. There are two important explanations. Explanation A, that even if the dispute involves recovery of immovable property, it will not be prohibited as a commercial dispute. As an example, suppose there's a lease and the lease involves recovery of immovable property. It will go to a commercial court. And merely because it is an immovable property, it will not be prohibited. But yes, what will be prohibited is if it is covered by the Rent Act. Two, if the state or an authority which discharges public functions is a defendant in these proceedings, it will not be prohibited. The state, there can't be any defense that the state is a party, therefore this is prohibited. So a commercial dispute, I please request you to just go through 2E 1 to 22. So now I'll quickly start moving towards the amendments. Section 2F is again an interesting amendment which defines the word document. Why I'm talking about document is because most of the disputes that come to commercial courts arise from contracts, some way or the other, whether it's an agreement to sell, or it's a contract for lease, or it's a franchise agreement, or it's whatever type of agreement, it will come here. But yes, disputes which do not have any commercial element will be excluded. You may be called upon to determine that at a particular stage. So please be very conscious of reading these sections and the definition of document. Sorry for paucity of time, I can't go through the definitions. But then there's another very important provision which has come in lately. That's section 12A. Section 12A makes it mandatory for pre-institution mediation. Now, pre-institution mediation, you can all understand, it's a very simple word, that before you file a suit, you must go in for mediation. But the issue here is, what happens when there is no pre-institution mediation? The section somehow seems to be silent or a little vague on that. So there has to be pre-institution mediation. But another exception, if there is an interim relief which is urgent in nature, then you can do away with this mediation process. As it is, most of you refer people to mediation. So that's the part of the mediation. I can't go through too much. Now, the amendments, let's quickly rush through the amendments. Form of pleadings. Order 1, parties to the suit remains the same. Order 2, frame of suit remains the same. Order 3, agents and pleaders remains the same. Order 4, institution of suits by plaintiff remains the same. The first amendment that comes in is Order 5. And that's the most important one, which comes repeatedly. It says when a person fails to file a written statement within 30 days, he can be allowed a maximum time of 120 days. That also after the officer concerned records reasons for allowing such time. And if after 120 days he still does not file a written statement, no further time can be granted. There's another provision that comes in later, which I'll refer to. So therefore, the defendant forfeits his right to file a written statement, and the court shall not allow him to do so. So I hope that is very clear. You'll have to use the word forfeits his right to file a written statement. Now, you're all aware that pleadings are contained in Order 6. So 3A says that pleadings where there are High Court rules and orders shall be filed in accordance with the High Court rules and orders prescribed in the rules, such rules as may be framed. But rest of the provisions remain the same. Then we come to Order 6. Order 6 contains a very interesting amendment, 15A. I can just read it out. Verification: when somebody comes to you with a commercial suit, please check his verification. And I can just read that part out to you. Just a minute. You may have read it, you can read it, but since I find it rather interesting, I think I should read it out to you. Notwithstanding anything contained in Rule 15, that's the rule. Every pleading in a commercial court shall be verified by an affidavit in the manner and form prescribed in the appendix to this schedule. An affidavit under Subrule 1 shall be signed by the party or by one of the parties of the proceedings or by any other person on behalf of such party or parties who is proved to be satisfactorily to be acquainted with the facts. Where a pleading is amended, now let me take you to the appendix. All right. Let me just take you to the appendix, and you can, in fact, you can read it. We needn't waste too much time, but please be very clear. There's a slight difference in the verification. Now we come to the plaint, because that's more important. 2A seeks to modify the provision regarding interest. That's Order 7. The rest of it remains the same. So please be very careful. Where the party has claimed interest, you will have to ensure that, I'll just give you the particulars, that it prescribes the rate, the date from which it is claimed, and the total amount calculated, the daily rate, etc. Please read it in detail. It's very different from the normal CPC rate of interest which you claimed at 18% per annum. That's all. Here you will have to go and make a specific reference to the rate of interest. And if he doesn't make it, it's up to you now to figure out what to do. So this is Order 7, Rule 2A, which is added there. Then rest of it remains the same. Now Order 8 is written statement, set off and counterclaim. Rule 1 is the same. That 120 days final time again comes here. Rule 3A. I'm reading Rule 3A, which has been added, which is very important for the courts as well as for the defendant. So I'm just reading that to you. I'll read Subrule 2. The defendant in his written statement shall state which of the allegations in the particulars of the plaint he denies. He must specifically say which does he deny, which allegation he is unable to admit or deny, which allegation he is unable to admit or deny, but which he requires the plaintiff to prove. This is a little tricky provision. Allegation he is unable to admit or deny and requires the plaintiff to prove, and which allegation he admits. These three things you have to ensure in the plaint, that in the written statement, that an averment to that effect is made. The idea behind this amendment is to shorten the procedure of proof of documents, etc., which I'll come to later. You all are aware of the fact that almost in every pleading in the written statement, it says para so-and-so is denied being false and incorrect, and then says, because I have no knowledge about this document. But he must now specifically refer to why he has signed a document. Why is he denying the document? Is he alleging fraud? Is he alleging undue influence? Is he denying his signatures? There must be a specific denial. And if he is unable to admit or deny, then he must say so, why he is unable to admit or deny, and that he requires the plaintiff to prove these facts. If he is going to make an admission, the admission then must be specific. So this is something important. Normally in the plaint, you say there must be clear pleadings, etc., by specific denial, but these words have been added. Then there's subclause 3 of this subrule. where the defendant denies an allegation of fact in a plaint, he must state his reasons for doing so, which I was just telling you. And if he intends to put forward a different version of events from that given by the plaintiff, he must state his own version. Now, this is a departure so as to ensure that most of the pleadings which are in the plaint are admitted or denied, or a request is made for the plaintiff to prove them, and then only with the question of admission and denial come in, or a document being read against the defendant become an issue for the court to decide. So if he denies an allegation of fact, he must state his reasons for doing so. So this makes it even tighter, even more. And if he disputes the jurisdiction of the court, he must state the reasons for doing so. We normally have clauses, say preliminary objection, the suit, the court is barred from entertaining the suit as it is barred by limitation. You know, Section 3 requires you to throw out a suit even at the outset if it is barred by limitation. But he must make specific facts. Why is it barred by limitation? And similarly, it says there you'll always find a paragraph, normally number 2 or 3, in the preliminary objection, that the court does not have any jurisdiction. If he says so, he must raise a specific plea of lack of jurisdiction of the court, of the prohibition of jurisdiction of the court to entertain the plaint. A general omnibus denial can be validly ignored by the court. You do it also, but we have all come across, and you also know, the court still goes and frames issues many times. So please be careful, look at these, use these provisions, and don't think that they are just meaningless provisions, and do not even think that they're all similar to the CPC. There's a huge difference. And then we come to Rule 3A. Just take out Rule 3A. No, it's there. It's there in the book. Come to Rule 3A, I've read. Then there's a proviso. If you remember, Rule 5 says specific denial. Now, this specific denial will be replaced by these rules. And then there's a proviso to Rule 5, which says, provided further that every allegation of fact in the plaint, if not denied in the manner provided in 3A of this order, this is very important, the one I was just reading to you, shall be taken to be admitted, except as against a person under disability. So those conditions I read to you, that sub-rules 2, 3, and 4 of Rule 3A, if not denied in the manner stated in these sub-rules, it will be deemed, provided sub-rules, it shall be taken to be admitted, except as against a person with disability. There's another provision which I just forgot to point out, that's 3A5, that relates to the valuation of the suit. And that also can't be without reasons. Normally, you say the suit is not valued correctly. So you must give a reason why it is not valued correctly. So this is a very, very important provision. And it's a provision that would enable the court, if implemented properly, to speed up the process of justice in commercial suits. Now the question comes, why commercial suits only? Well, because in commercial suits, a lot of money gets tied up. And you're all aware that a country or even a people, it's the economics that is important to today's times. And since we tend to move towards a capitalist economy, there is something known as the ease of doing business. And in order to achieve those ratings, all these provisions have been amended so as to that ease of doing business. Now, if you have a suit for eviction on the basis of a lease deed, which is not covered by the Rent Act, you will file a suit for possession under the Commercial Courts Act, read with the CPC. And if you plead in this manner, it becomes much easier. I'm putting it from the angle of a lawyer, because though you are all judges, you will examine it from the angle of a lawyer, that has he pleaded all these things. So you must understand what a lawyer is required to plead and not just what a judge is required to decide. Because till you don't understand what a lawyer is required to plead, it's you do not understand the essence of a provision or the essence of a right. So please understand, if the lawyer does not plead this, then you will ask him the question that why should I not, that same procedure, that since you've not pleaded this, I'll take this as an adverse inference against you. Now we come, I'm sorry, there is actually this topic in itself. I request Dr. Balram Gupta to have separate small modules for this act, because though this is something we all know as lawyers and judges, that denials etc. should be specific, but we've never had a provision which is prohibitory in nature, which says if you don't do this, then finished. The whole suit will finish if you don't do it, if your denial is not this. Now we come to again that same proviso that prohibits the court from extending limitation at all beyond 120 days as far as the written statement is concerned. Then we come to Order 9, which remains unchanged. We come to Order 10, which again remains unchanged. Then we come to discovery and inspection. Discovery and inspection under Rule 11 is totally different from what is in the CPC. Please, I cannot take you through this entire voluminous document, but please read this entire document. This, I say document because it's rather long. So Rule 11. Now, what is interesting in this is that now, earlier we always filed documents with the plaint. Okay. These are now codified in sub rules 1 to 16, 1 to 6, sorry, and the written statement or counterclaim in 7. I'll just briefly refer to you what documents have to be disclosure and discovery of documents. Plaintiff shall file a list of documents and photocopies of all documents in his power, possession, control, or custody pertaining to the suit, along with the plaint, including documents referred to, relied on by the plaintiff in the plaint, etc., etc. Nothing in the rule shall apply to documents proved to the plaintiff and relevant only for cross-examination. Then it goes on and on and on. Then it's settled. Then 7 is the defendant shall file. Similarly, it goes up to the defendant and also in his counterclaim. And then it makes its rather long. Then it refers to electronic records. So everything is there: inspection, discovery, how to go about it. The entire chapter on disclosure, discovery, inspection of documents is in Rule 11. So anybody interested, as far as I know, not too many of our judges in Punjab and Haryana use this procedure, but I find this is used very often in Delhi, and it's a brilliant procedure to cut down the entire matter. The only thing is that you'll have to control it. What happens is lawyers are habit of saying that this document is denied, but they do not refer to why this document is denied. So even when you come to the admission and denial portion, this is something you will have to look at. You cannot possibly just allow the lawyer to lead you by the nose. You have to have control of the proceedings. So this is a provision. Please, I request all of you to also study when the plaintiff is filed, that please examine, or the written statement is filed. And then it also has about the electronic records, etc. The entire thing is there. So this is a very important detailed provision this time. And we normally had these provisions, but now they've gone into greater degrees of detail. Then we come to order admissions remains the same, order 12, order 13, and then we come to order 13A. If you are going to be in a commercial court, you will have to acquaint yourself with the original procedure of summary judgments in the CPC, of rendering summary judgments. But thereafter, you'll have to read 13A, order 13A, which is call it the heart or the heartbeat of the Commercial Courts Act. And it also permits you to pronounce a judgment without oral evidence, also permits you to record oral evidence. But then at every stage, you will be under Rule 2. It gives you the stage of summary judgment and how it is to be applied. It's slightly different from the original procedure, and grounds for summary judgment, then the procedure for summary judgment, and then we come to orders. You can pass a conditional order, you can pass a judgment, you can dismiss the application, you can dismiss part of the claim and a judgment or a part of the claim. You can strike out the pleadings, you can issue further directions to proceed. Whether the court makes an orders, as in somewhere, the court shall record its reasons for making such orders. So, though it's already there, but this makes it better. Then it goes on to define what are conditional orders and then power to impose costs. So this is basically of summary judgment. And there's something very interesting in this. Then I'll just take you straight away to order 28. Just turn to order 28. This provides as to how written arguments are to be filed. Rule, I'll just read out. I'm sorry, it's 18, not 28, my mistake. Sometimes I also get confused with this Roman numerals. Order 28. Written arguments, rule 4. Just take it out. Just excuse me, I'm running a little cold. Rule 4. 1 minute. Just a minute. Rule 4 allows you, sub-rule 4 of this, may by direction regulate the evidence as to issues on which it requires evidence and the manner in which such evidence may be placed before the court. And then it says redacting or rejecting evidence and format and guidelines of evidence is rule 6. An affidavit must comply with the form and requirements set forth below. What we do normally in courts is an evidence is a repetition of the pleadings in the plaint or the written statement and nothing more. Here, the affidavit is very, very different. It should be confined to and should follow the chronological sequence of the dates and events and that are relevant for proving any fact or any other matter dealt with. Where the court is of the view that an affidavit is a mere reproduction of the pleadings or contains the legal grounds of the party's case, the court may by order strike out the affidavit or such parts of the affidavit as it deems fit and proper. This is sub-rule 6B. Each paragraph on average should, as far as possible, be confined to a distinct portion of the subject. An affidavit shall state which of the statement are made from the deponent's own knowledge? That is the question of verification. So now under the Commercial Courts Act, you will have to regulate the filing of the affidavit. And in case the affidavit is not filed in accordance with Rule 4, the format and guidelines of affidavit evidence, you can suggest to the person that please amend your affidavit or change your affidavit, subject however to the defendant screaming and shouting that he can't do it. So you are in control of the entire proceedings. It's not as if you are standing there as a silent spectator and allowing the lawyers to do whatever they want to. Now, a small request to all of you that it's not as if you are sitting there as an umpire or somebody who's just standing by. This act now empowers you. In fact, the original CPC also empowered you, but lots of us allow lawyers to run the entire show. You must, in my opinion, if you want to render this procedure relevant and not render it another piece of the CPC, as has happened to all other amendments, you must implement this. Now, there's another important, very, very important provision which grants you 90 days to pronounce judgment. Just take that out. And before that, we have 19. I'll just take it to 19. It's in the old act, in the act itself. So, you have 90 days to pronounce judgment. Take it from here, just take it from here. And there is something new this act has put in, statement of truth, called statement of truth. I don't know how far you will be able to implement it, but in Appendix 1, there's under first schedule order 6 Rule 15A, order so and so. The deponent do hereby solemnly affirm and declare as under, there is a statement of truth to be given. And this statement of truth is more or less something like the original the verification, but this time it's in the shape of a separate affidavit, and which, if not found to be incorrect, you can always dismiss the suit on this account for filing a false statement of So basically, I've just taken you quickly through these amendments, which broadly speaking will fall into these broad formats, and there's nothing that is so scary about this act. It's just a procedure that quickens up everything. Now, in my opinion, each one of these amendments, or maybe one or two together, like you can have the pleadings together, the form of evidence together, the provision for how and in what manner summary judgment, because it's very different from the old summary judgments, would require, if at all anybody so likes, a complete separate discussion. And apart from all this, this includes a mandatory case management system, which was also there earlier, which the High Courts had implemented, but now it's part of the Act itself. In Section 6 of the Act, and this is prior to framing of issues, hear and decide any pending application filed by the parties under Order 13A. Direct parties to file compilations of documents or pleadings relevant and necessary for framing issues. You can even at that stage call for all this. Extend or shorten the time for compliance with any practice, direction or court order if it finds sufficient reason to do so. You can shorten the time for compliance. You can extend the time for compliance. Adjourn or bring forward a hearing if it finds sufficient reason to do so. In brackets in all these provisions read for reasons to be assigned, those not said so. Direct a party to attend the court for purpose of examination under Order 2, Rule 9. Consolidate proceedings. Strike off the name of any witness or evidence that it deems irrelevant. Direct a separate trial of any issue. Decide the order in which issues are to be tried. Exclude an issue from consideration. Dismiss or give judgment on a claim after a decision on a primary issue. Direct the evidence be recorded by a commission where necessary in accordance with Order so and so. Reject any affidavit or evidence filed by the parties for containing irrelevant, inadmissible, or argumentative material. This is an extension of what I just told you about that rule. Strike off any parts of the affidavit or evidence filed by the parties containing irrelevant, inadmissible, and argumentative material. Delegate the recording of evidence to such authority appointed by the court. Pass any order relating to monitoring. Order any party to file and exchange a cost budget. Issue directions to pass an order for the purpose of managing the case and furthering the overriding objective of ensuring the efficient disposal of the suit. When the court passes an order in exercise which passes under this order, it may make it subject to conditions, including a condition to pay money into a court and specify the consequences of failure to comply with the order. While fixing a date for case management hearing, the court may direct that the parties also be present for such case management hearing, if in its view there is a possibility of a settlement. The court shall then, the next one, shall not adjourn the case management hearing for the sole reason that the advocate appearing on behalf of a party is not present. Provided that an adjournment of the hearing is sought in advance by moving an application, then it can. Now, this case management is something that will enable a commercial court to not only fortify the provisions of the commercial court amendments, but also itself. Because there's another provision which says consequences of non-compliance with orders, where any party fails to comply with order of a court passed in a case management hearing, the court shall have the power to condone, foreclose, dismiss. All these things are there. So it's not a case where they have just shifted commercial courts from ordinary courts to a commercial court. The entire method of working, the entire method of consideration has changed perceptibly. So I think my request to the Academy is that this is a thoroughly inadequate session as far as I'm concerned, and I know the paucity of time. So I'll once again request the director that this entire part, you may have already heard it, should be made into separate modules. Case management, a separate module. Discovery, inspection, and documents, a separate module. Mr. Gupta, I'm sorry addressing you directly, but all these things are very important. Very important because soon we'll have many of our commercial courts floundering because in Punjab and Haryana, the High Court does not have original jurisdiction. In Delhi, I would like to inform you, the High Court is exercising these bars because it has original jurisdiction. So things are slightly different in Delhi and different here. And another small request that the rules framed by the High Court under this Act may also be, I think all judges who are dealing with these cases are not even dealing, should be provided a copy with the rules also, because any day they are going to be concerned with this. I think with that, this brief, call it just a flight from Chandigarh to Delhi of 45 minutes is now over, because if I say anything more, then I'll encroach upon Justice Pratibha Singh's lecture, I think, which she must be waiting for. So I think that's all I have to say. And if anybody has any questions, sir, please ask them to send it to the academy. I'll be only glad to answer those questions, even by mail or anything you feel.
Thank you so much, Justice Bhalla. See, I totally accept the suggestions made by you. This time capsule was absolutely inadequate in order to cover effectively the session as such. I'm one with you, and the suggestion further which you have given certainly would be taken care, and we would look forward to that as such. In fact, right in the beginning of this session, Justice Bhalla focused on this aspect, that these amendments in the Civil Procedure Code, why only the commercial courts? Why not other courts also to follow this particular procedure as such? Because the ultimate object is speedier, effective adjudication of the commercial disputes. And this particular parameter or a barometer is equally applicable to the other jurisdictions as well. And therefore, this particular suggestion is very well taken up, and we look forward as to what we can do in this particular context. We would certainly look forward to that. And finally, the offer which Justice Bhalla has made, that those participants, judicial officers, who have any particular queries, questions relating to this aspect, can refer those particular queries to the academy, and we would share those queries with Justice Bhalla, and so that we could take care of the issues and problems which confront particularly the judges who are manning the commercial courts in the district level as such. Justice Bhalla, so very kind of you. You are always very generous, magnanimous with us. Your contribution to Chandigarh Judicial Academy is immense. And this association with the Academy, we keenly look forward to continue as such. Grateful to you, sir, and
thank you,
look forward.
sir. Can I now switch off?
Thank you so much. That's very kind of you.
That's all we've learned in the 2 years of COVID.
That's right. That's right. Thank you so much.
Okay, sir. Thank you very much. Bye bye, and thank you for having me. And thank you everybody for patiently listening to me. But this is totally inadequate. Thank you. Thank you, sir.
Thank you.